Good afternoon, everyone. I think we are ready now. A warm welcome to everyone who has tuned in to this webinar, A Practical Guide to IP Fundamentals in partnership with Mathys Squire, which will be presented by Sam Giles, UK and European patent attorney, and his colleague Harry Rowe, UK and European trademark and design attorney, both from Mathys Squire. For those who do not know me already, my name is Gunnar Larsen. I'm the Managing Director of the Danish-UK Association, and I'm delighted to be your host today. Moving on, about the firm, Mathys Squire, I'm pleased to say I have been a member for several years of the Danish-UK Association, is Europe's premier intellectual property firm providing patent, trademark design, litigation services across a range of fields from electronics, engineering and manufacturing, IT, software to biotechnologies, chemistry, life sciences, and I'm sure I've forgotten something here, but they cover a lot, for example, including food that I did not mention. The firm worked with a range of organizations from SMEs and startups through to public sector bodies, universities, multinational enterprises, covering the full spectrum of industries. So without further ado, let me start introducing you to the presenters today. And my great pleasure to introduce you to the first speaker, who will be Harry Rowe. He is a UK and European trademark and design attorney, whose main areas of practice are trademark clearance, prosecution, contentious and post-registration matters, as well as portfolio management. He will be followed by his colleague Sam Giles, UK and European patent attorney, who has expertise in medical device technology, computer software and manufacturing. Sam has extensive experience in drafting and prosecuting patents in the UK, Europe and US, as well as further afield. Both our presenters work with a range of clients, including entrepreneurs, SMEs, multinationals. So without further ado, I'll hand you over to Sam to take it from here. Thank you.
So the purpose of this session is to give an overview of intellectual property, including trademarks, designs and patents, and to discuss confidentiality, non-disclosure agreements and their uses, as well as how to protect trademarks, and then what are designs and patents and why they're useful, and what is freedom to operate. So let's kick off with confidentiality. One of the most important things, especially for startups, is to consider keeping information confidential. If you publicly disclose your idea, then that may be prejudicial to you getting a patent and could stop you getting a patent validly granted. We often get patent inquiries, and I had one relatively recently, and it was a very interesting idea. But when I looked through their email at the bottom, they had a link to their website, went through, and it was clear very quickly that they had already started selling their product, and therefore we just weren't able to help them get a patent, and therefore they lost, a potentially valuable asset. So it's really important that you keep that in mind. There's also value in keeping information confidential, even if you don't plan to register IP in the future. I know that at our firm we dealt with at least one IP license agreement where the controlling IP wasn't any registered rights, but was actually just confidential information that lasted longer than some of the rights associated with it. And therefore, it can be really important to keep ideas confidential. So how do you do that? Well, non-disclosure agreements can be really useful. We're aware that, particularly with startups and SMEs, trying to gain investment, it can feel like a bit of a loop, trying to make sure that you can talk to people about your idea whilst trying to keep it confidential. And by having a non-disclosure agreement in place, this can allow you to impart information in confidence. There are some drawbacks with NDAs. For example, not all parties are willing to sign them. And if this is the case, it can lead to some barriers. And there are also other particular drawbacks, such as if you are asked to sign a mutual NDA. If you're asked to sign a mutual NDA, this means that both you're going to give it confidential information and you may receive it. And if you're not clear about what information you receive is confidential, you may have an obligation placed upon you that you don't really understand and that you don't know the scope of, and that can be a risk. There are also problems if you, for example, have an NDA signed and it's under a jurisdiction that's potentially far away or very costly. So if you're a UK European-based company and you're asked to sign an NDA that, for example, is under the law of Japan, it could be very difficult for you to enforce that in the future. And finally, record keeping is fundamental. If in 2 to 3 years' time there's some kind of dispute, it can be really hard to prove what you said in the discussions covered by an NDA unless at the time you have records to show exactly what was said and by whom. So confidential know-how can be really useful. I mean, if you think about Coca-Cola, they must have launched well over 100 years ago, and their recipe is still a secret, which means it still has a high value that will continue long into the future. So there's a lot of value in taking this approach. However, it's important to note there are different rules governing trade secrets in different jurisdictions. So what may be considered a trade secret in one country may not be in another, and it's worth making sure you reach the necessary obligations in any countries that you're considering using this approach. So what IP is relevant? Here we've got patents, designs, trademarks, copyright, know-how, and utility models. And so patents are typically about how something works. They kind of protect an underlying idea or a technical implementation. That's quite different, for example, to copyright. So copyright protects an expression of an idea. So I think we're all comfortable with this in terms of music and art. But for example, in software, the source code may be protected by copyright. So if someone directly copies your source code, you may be able to use your copyright to mitigate that. However, if you have an algorithm, then unless you have a patent protecting the process behind that, then the copyright may not be that useful if someone just copies the algorithm but expresses the code in an entirely different way. Designs protect the aesthetic appearance of a product, and that could be packaging, look and feel, or graphical user interfaces for software, whilst trademarks protect branding and logos, and we've already touched on confidential information and the value that that can bring.
If I may, there's one thing that I should add. The previous slide is a good tool to have because it will show you that how the different rights interact, and it's always important not to consider IP rights in isolation. A good IP strategy will be one where someone considers all the various rights and takes a holistic approach to them. Although I appreciate that commercial decisions might be made with respect to which one to register first between patents, trademarks, and designs, but obviously we can advise on that and which strategy to adopt.
Thanks for that, Harry. So, why do people patent? Well, I'm sure yourselves and others have spent a lot of time on research and development and a lot of resources making sure that you've really perfected and refined your inventive concepts. And if you don't protect that, then a lot of that research and development can be lost. So this is almost an investment in that R&D, and it produces an asset, one that can be bought, sold, or licensed, and used as a commercial tool to dissuade others from entering a market, or to show that you are cutting edge in your field. So what is patentable? Well, here we've got a range of different technology. So on the left, you've got a mechanical device, Lego, and that was patented back, it was in the 50s. In the middle, you've got some kind of telephony invention that's to do with how mobile phones interact with the base station. So that's kind of a mixture of a process and hardware. And then on the right, you have a low resolution to high resolution image processing method. So that's a software implemented invention. And each of those is potentially patentable, of course, dependent on the particular invention. So what do we consider when we're talking about whether something is patentable? Well, the first test is whether the idea is new, if it's different to what's come before. So in the example on this slide, we have a blue squash ball. Now, prior to the blue squash ball, there were squash balls that were black or green. And when someone produced a blue one, that was new. So that passes that binary test. The second part of the patentability test is whether the idea is inventive. And the inventiveness threshold is a lot lower than people expect, especially when it comes to engineers who are used to dealing with technical matters. Engineers often think that what they've come up with is just simple, or it's merely an iteration on what's come before. But the legal test of whether something's inventive is whether it's obvious. So in this case, only the color is changed, about the time the invention was made, there wasn't any use of blue squash balls or any particular use of blue balls in sports in general. And as the human eye is particularly adapted to seeing movement in the blue color range, this idea had an advantage, and so it wasn't considered obvious, and therefore it passed that inventiveness threshold, even though it may seem like just a small difference when you first consider it. So what's the procedure for obtaining a patent? Well, first of all, just off the slide is the bit that you do, where you come up with an invention or an idea, and then you come to us, keeping your idea confidential, and we draft a specification. We go forwards and backwards whilst we draft that with you in a collaborative process. First of all, often drafting the claims, which define the scope of protection, and also the description describing how it may be implemented with corresponding figures. Once that's been agreed, we file the application at a relevant patent office. That might be, for example, the European Patent Office or the UK office. The patent office will then perform a search. This typically takes 6 to 9 months, and they'll identify any documents that they consider to be relevant. And it will give us a good indication of what kind of protection we think may be possible. Within the first 12 months after filing, you have the opportunity to file further applications claiming priority to your initial application in other jurisdictions, so in other countries such as the US or Japan, etc. And the initial search that you receive from the patent office can be quite useful in determining where to seek protection and whether you should do so. 18 months after filing, your application is then published and it's publicly available, and you then go through an iterative examination process. So the examiner may just wave your application through and say that it can lead to grant, or they may have some objections, and they often do. These could be a mixture of formal objections, or they could be substantive and may require some more amendment, which we can discuss at the time. So patents are commercial tools. Firstly, they allow you to exclude others from the market, and they can act as a deterrent. I know that we worked with a client, and they, after some time, merged with one of their competitors, and it's quite nice being able to, eventually talk to the attorneys on the other side of the divide. And they told us that the competitor hadn't moved into a specific technical field because they were deterred from doing so from the patents that we had on file. And that shows the power of patents as a keep off the grass sign. They can also be used as a negotiating tool. Again, if a competitor has some IP, then at some point you may end up rubbing against it, and it can be quite useful to cross-license rather than get into a more difficult, timely and costly dispute. So they can be used to try and resolve matters in that way. It also can be a public statement of ownership and a public statement of your research and development. And in some countries, such as the UK, there is a tax incentive for getting them. And especially for smaller clients, it can be used to seek investment. A lot of investors really want to see that an idea is protected before they're willing to put their money in. And of course, an IP is an asset and can be bought, sold, licensed or mortgaged, and so can lead to an entirely different business strategy once it's in place. So, registered designs, these protect the aesthetic appearance of an object. So we have everything from packaging to patterns for cloths, household goods, consumer electronics, even logos or graphical user interfaces for websites or in apps, etc. So when you're registering a design, they aren't substantively examined. So as long as you fulfill the formal requirements, the registered design application will lead to grant. But not all granted registered designs are valid. So how do we know if they are? Well, they must be new. So like patents, if there's a difference, then that covers that threshold. And then a design must have individual character. And what does this mean? Well, this means that when you look at the design and you compare it to what's gone before, it gives you a different overall impression of the design. And that's quite dependent on the field it's in and the design freedom that the designer has. So when we talk about the scope of registered designs, this encompasses that same test, whether a product has the same overall impression as the registered design. And as I said, this is based on the field the designer is in. This is probably best seen when we consider the Apple and Samsung cases, in particular relating to the Galaxy tablet. So Apple alleged that the Galaxy tablet infringed one of their own designs, and it was found that there were small differences between the Galaxy tablet and the registered designs. And Apple argued that those were not big enough to create a different overall impression, but the judge in the end came to the decision that because there were so many phones and tablets that had designs that were so similar, that the overall impression was changed substantively from just small changes to the actual product, because the products in the field were all so close. And so the scope of the designs was quite small. So that contrasts with the opposite end of the scale. If, for example, you create an entirely new product that's different to anything out there, and you file a registered design for its appearance, well, then the scope of that may be quite broad, and something that may be a little bit more different may still be within the scope, dependent on what's come before. And then to the right of the tablet, you'll see the Trunki suitcase. I'm sure in more normal times, some of you will have seen children riding around on these in airports or train stations and the like. And they're effectively suitcases that are designed for children to ride on. And there was a case a couple of years ago alleging infringement of the registered design. And what was interesting about this was that the applicant had actually registered the design themselves without seeking professional help. And so had registered an image that had quite a narrow scope because they weren't aware of what all the rules were surrounding the scope of registered designs. So I really would suggest that you go to an attorney in order to help guide you in what should be filed. Another thing that people often ask us about is freedom to operate and how to mitigate risk. So, first of all, intellectual property such as patents does not give you freedom to operate. Just because you have a patent for something doesn't mean you're allowed to go and make or sell that product. A patent is a negative right that allows you to exclude others from a marketplace. And so there may be other rights that could exclude you as well. So businesses often lower their IP risk by performing a freedom to operate search, often called an FTO. And the appropriate level of searching depends on the nature of the business. If you're larger or smaller, if you're putting a lot of investment, for example, if someone is tooling up a manufacturing line to go into a new field, then it might be worth doing a significant amount of searching. And this can depend on whether you want to just monitor competitors, or if you want to look at the whole IP landscape in that technical field as a whole and really assess if there's any risk to you. Another thing to bear in mind is that if you have one or two significant customers, it may be worth monitoring their IP filings. Or on the other hand, if you have a supplier, it may be worth monitoring what they're filing just to see what they're doing, because that could impact you as well. So when it comes to third-party rights, there may be third-party rights that you're not aware of. These might be relevant to your commercial activities. And some years down the line, a third party may request a license fee from you, or at the very worst, could sue you and try and stop you from doing what you're currently doing commercially. So how do you mitigate this? Well, you can perform an IP search to make you more aware of the risks, and filing your own IP rights can really help with cross-licensing and negotiations. And especially when you get to really complex products that are made of multiple components, often that's the best strategy. And so you look at some multinationals and they'll file hundreds or even thousands of patents because that's also the best defensive strategy for them. When we talk about third-party rights, that could be any third party, but it might be specific competitors that you know are in the field and that you really want to keep a close eye on. And it's often worth putting a watch on for their filings. So if you have a customer that's particularly important and, for example, you're producing a component for them, well, they could register their own controlling IP that could stop you from selling to other customers, at least in the same technical field. If they do that, then obviously that puts them in a better position in terms of any future negotiations and could change the price point or your profit margins and impact your freedom to operate with other parties. So how do you mitigate this? Well, perform an IP search, watch what they're filing, and file your own IP rights to help with cross-licensing negotiations. Similarly, you may have a supplier and you may work with them for many years, and at some point you may want to vertically integrate just so that you're producing those components yourself, just to increase your profit margin or to be able to increase the amount of product that you can make. But if the supplier has, for example, registered their own rights in terms of the components that they have made for you or a manufacturing process, that can tie you in almost and stop you from doing that. And it may also mean that they're able to dictate pricing in the future. So there are a few ways around this. IP agreements could be really useful. So at the beginning of a collaboration like that, it could be really useful to know who's going to own what IP, so that you know that they can't do this, and also to monitor their filings, check if they have filed anything. And again, to file your own IP as a defensive strategy is always a good thing that's worth doing. So are there any questions about patents or designs?
Sam, I have one. While thinking about the questions, could you give some examples? You say there's a difference to how trade secrets are defined in various jurisdictions. So just looking across Europe, for example, could you maybe give an example of a product or service or something like that, where you see one country has looking upon it differently than the UK, for example?
Yeah, of course. So I think one of the best countries actually to look at this with is the US, and with trade secrets. There was a case recently where an employee of Uber had switched to Google and had taken some trade secrets with him, and they actually just had a criminal investigation that led to that person ended up getting a custodial sentence, which is very different to how it would work if that same matter had come up in the UK. And if you look at the rules regarding trade secrets in America, obviously I'm not a US attorney, but although they bear some resemblance to confidentiality in the UK, every jurisdiction has slightly different rights, and it's always worth bearing that in mind.
Okay, good. Thank you. While people are pondering about the question, I've got plenty more, but I think we should let you guys go on and maybe continue with Harry.
Thank you. Hopefully I've taken control of the slides now. So I'm obviously going to speak about trademarks today. This table here I think is slightly outdated, but you know, it serves a purpose of showing you where brand value can sit in the company's priorities. So obviously some of these companies have enormous brand values, particularly when you look into in comparison to the amount that they spend on advertising. Now, why should you protect trademarks? And there's a number of reasons. One of which, like patents, they can be a commercial tool, so they can be licensed, transferred, or act as security for investments. They can also protect the investment by the owner in their marketing and development of their brand by being used as a tool for preserving its distinctiveness. We'll come on to that a little bit later. Again, like patents, it's a company asset that has a value attributed to it. And it advises consumers that goods and services originate from a particular business. And as I mentioned, it can act as a deterrent to stop others from registering similar or identical marks. So what constitutes a trademark? Well, they can take a number of forms. Perhaps the more standard is a word mark such as Google or Kodak, but equally a trademark could be a slogan or even sounds, colours or smells. Now, when we file trademarks, they will be trademark applications. They'll be examined to check that they are inherently registrable, and there's a number of factors that the examiner will take into consideration. But the two key concepts are whether the mark is non-descriptive for the goods and services filed, and whether it's distinctive, so whether it can distinguish your goods and services from those of a competitor or another business. And the examiner will take into consideration these tests based on the goods and services filed. So a mark might be distinctive for certain goods and services, but not for others. And there's a scale of distinctiveness, I guess, which I've tried to demonstrate here, with the most distinctive marks being invented words such as Xerox or stylistic logos. Next, you really be looking at unrelated words. So, for instance, if you think about Apple for consumer electronics, it's a distinctive mark, but if you were looking at it for food produce, then it wouldn't be so distinctive. Next would be elusive words, so words that allude to a quality of the products or services. Further down on the scale are slogan, shapes, colours, smells and sounds, and descriptive and generic marks. And these are typically very difficult to register. Now, trademarks can acquire distinctiveness through use over a number of years, but the less inherently distinctive a trademark is in the first instance, the more evidence an applicant would need to file to show that a mark has acquired that required level of distinctiveness to reach registration. And when we file trademarks, we obviously have to consider what scope of protection we're looking for in the application. And it's about striking a balance between obtaining the broadest scope of protection available and balancing that against the risk posed by earlier trademarks that might be considered similar or identical. And one way of trying to overcome some of these risks posed by earlier marks might be by adding different elements to the trademark. So it could be adding a distinctive word or stylizing it in a way. So the broadest scope of protection is afforded to distinctive word marks that are filed in standard characters. So trademark registration allows you to protect your mark against the use and registration by a third party of similar or identical marks. And word marks would tend to be considered more similar to other word marks than a word filed in a logo or stylistic font. So that's why you can see on that scale that the word mark in standard characters tends to be afforded the broadest scope of protection in comparison to a logo mark or a mark filed in a distinctive font. The procedure for obtaining a trademark registration is slightly similar to a patent, but obviously there's differences. And this slide is based on a UK application. So we typically advise that a search is undertaken before filing any applications. As I mentioned, there may be risks posed by earlier third-party rights, and a search will highlight these risks to you, and the search report will allow you to, will advise on ways that you could attempt to mitigate that risk, as I mentioned, by maybe adding other stylistic elements to the mark or adding a distinctive word. And as you can see, it takes around 4 months from filing to registration in the UK, but that was pre-pandemic. The pandemic has slowed processes down at the moment, so you'd probably be looking at about 6 months. So once we've done the search and you're happy with the level of risk, then we would draft the specification of goods and services. Now, it's very important to remember that once an application has been filed, you cannot expand on the goods and services filed under that application. We can only narrow it. So it's worth spending some time to draft the specification carefully to ensure that you've covered goods and services that you're likely to provide in the next 3 to 5 years and possibly in the longer term. Once we have the specification ready, we can file the application. And from that date, that filing date, there's a 6-month period, the priority period, where foreign applications for the same mark can be filed, claiming the first filing date. So effectively, you can backdate a foreign application to that first filing date. After filing, the trademark is examined, as I mentioned, and assuming that it goes through examination smoothly and the trademark office accepts it, the trademark will be published for third parties to oppose. That publication period in the UK is 2 months, which a third party can extend to 3 months. If nobody opposes, then the trademark will go through to registration, and it's important to note that that's not the end of the road, and I'll touch on that slightly later. One thing also to highlight is during the examination stage, in some countries, trademark examiners can reject an application if there are similar trademarks on the register. In the UK, the examiner will perform a search and write to any holders of UK trademarks that they consider similar to invite them to oppose, but they won't refuse an application on that basis. But in countries such as the US and China, they could do, which is why searching is quite key if you're looking at those markets. And as you've probably gathered, trademarks are territorial, so the scope of protection of a trademark will only extend to the territory in which it's registered. So you couldn't use a UK trademark to prevent someone using that same trademark in the US, unless you've gained a very significant reputation, which can be quite difficult to prove. So this is why it's important to plan your strategy early on to ensure that you're covering all the territories where you're likely to use the mark in the next few years. So for instance, you should consider whether you'll be manufacturing in China and considering protecting the trademark there if you need to. As I mentioned, there's the option for priority claims, and this allows applicants to spread the cost or delay the cost across 6 months. So that could be quite a good key if you're a startup or SME to, that's quite a good way of thinking about where you're really going to operate in the next few months, get a strategy in place and potentially seek investment during that time. And finally, some countries operate what's called a first to file regime. So China is a good example of this. So irrespective of whether you've used the mark, someone in China could apply to register that mark, regardless of whether they have a genuine interest in it. And these marks can be incredibly difficult to knock out, particularly if you've not really used your mark very much. So what we would suggest is that you look to file in these first to file countries early on to avoid having to avoid coming across stumbling blocks later down the line when you try to register your mark in those countries. And beyond registration, so trademarks are perpetual. As long as you renew them, then they will last forever unless they're attacked. And the renewal period is usually between 7 and 10 years. It's 10 years in the UK. As I said, it's not the end of the road. Third parties can attack your trademarks even if they're registered. I think this is what a lot of clients don't realise. They think that once they've got the registration, that's them set. But a third party could invalidate your trademark if they have an earlier similar right, or if you haven't put your trademark to use in a certain number of years. In the UK, you must put a trademark to use within the 5 years after the trademark registration date. If you haven't put it to use, then a third party could apply to revoke it for the goods and services that you haven't used it for, which is why I tend to advise when filing a trademark to think about what you're going to be doing in the next 3 to 5 years, as that would protect your interests while also not opening up too much to revocation actions if you're unlikely to use the mark on products. And how to defend these cancellation actions, it's imperative that you keep records of your use. So this could be materials such as catalogues, marketing materials, articles by third parties are generally quite persuasive, but also keep records of your investment in marketing and your sales figures for goods and services sold under that trademark. And finally, one thing to mention would be that you need to preserve the distinctiveness in your mark and the value in the mark by policing the register. We can set up watch services so that we can actively watch what is being filed by your competitors, or watch a certain mark to check that similar marks are not being registered. And this preserves the distinctiveness, because the more marks that are similar that are on the register to your mark, the less distinctive your mark becomes. So it's worth taking action to preserve that value in the mark. And my last slide, I'm sure everyone's bored of hearing about Brexit now, but the practical point to note is that following the end of the transition period at the end of this year, registered EU trademarks will be automatically cloned to UK equivalent marks, but any pending EU trademark will not be automatically cloned. It will be necessary to refile that mark in the UK within 9 months after the transition period. So because the EU trademark application process tends to take around 5 months, any EU trademark filed now will not be automatically cloned to the UK unless the transition period changes. I think that's everything.
Just on Brexit, I think with patents it's worth noting that the European Patent Office is unaffected by Brexit, so you'll still be able to file European patent applications that cover the UK as well as other countries in Europe and other countries that aren't in the EU as well, but are part of the EPO.
And also another point is that EU designs will follow a similar process to EU trademarks, but because the application process is so quick for EU designs, it's unlikely that it will affect many of them.
Good. There's actually been some questions, Harry, I'm pleased to say. There was one from Tony. Can you give examples of third-party rights that may cause a problem?
Yes, so there's various rights that could be used to invalidate or oppose a trademark application. So obviously, owners of earlier trademarks that are similar could oppose your application. But also, if you filed a logo mark, then someone could apply to oppose it on the basis of copyright in a similar mark or a similar logo. So it's worthwhile doing these searches and also thinking about common law searches to see what marks are also in use as well as on the register.
Good. I hope that was an answer, Tony, you could use. If not, please come back. Then there was a question from Søren. The slide with the 3 examples going from products to services. Which of these are patented and how is the service patented?
Sorry, I was on mute.
Yep.
So when we talk about patents, we've got various different fields in which you can get a patent. For example, if you are working in pharmacology, you may be looking at patenting a specific molecule or medicine that you create. When it comes to more my field, I work with mechanical inventions all the way through to software. Software has a tiny bit of more to it in terms of the requirements, in that you have to prove that you're addressing a technical problem and that you're providing a technical solution to that problem. So you have to consider that. Whereas a mechanical invention, you pretty much have to consider novelty and inventive step, like we discussed, and it's more of a traditional application in that sense.
Good. So come back if you need that expanded. Then we had a question from Danielle. Companies often alter their logos over the years, for example, Starbucks. These looks very similar to the original. How can they pass the registration criteria?
Yes, so obviously if you own earlier trademarks that are similar to your new trademark, there shouldn't be an issue. I think the point here will probably be about whether a mark could be vulnerable to cancellation if it's not been used, if a company is using a new version of a logo. Now the assessment is slightly ambiguous. It would be whether the new logo creates a new overall impression on the consumer than the old logo. So small insignificant details. So a mark used with small insignificant details compared to the registration would probably still constitute use of the registration. But once you start making more significant changes to a logo, that's where you might have more difficulty in proving use of that registration. And in that instance, you might consider refiling an application for the new version of the logo, whilst also maintaining the old version to ensure that you maintain those earlier rights and the longest duration of rights in that mark.
Good. Then, was there any add-on to that? Sorry.
No, I think that's it. Thanks.
Okay, very good. Then we had a question from John. As an architect, I wish to pitch development ideas. How do I best protect the idea being used without my involvement? Is that an NDA? And I guess that's a question really that goes across to other design ideas you need to put in front of the client. How do you protect yourself?
Yes, so an NDA, a non-disclosure agreement, would be such that it couldn't be disclosed publicly by that third party. And if you do that, then they shouldn't be able to use it in that way. Also, if you register a design or a patent for architecture, I guess it could be either of those things, depending on if there's some engineering behind it or if it's about the appearance of the building. If you could register a design potentially, then that may help as well. Going into negotiations, we always tell people that although an NDA is a good thing to have, it's not the be-all and end-all. It's not as good as actually having rights on file before a negotiation or a meeting.
I should probably add that you might also have, you'd likely have copyright in any images of the buildings that you create. So someone couldn't copy the design image of that building. Otherwise, it would constitute copyright infringement.
And I guess that question also, that goes across the board. It's all relative to cost here, isn't it? How can you prepare in advance for what to expect in terms of cost-wise? Have you any? Is it a percentage? Is it a fixed fee, or do you have any comments to that?
So when it comes to patents, for example, it kind of depends on the technical complexity of the subject matter that you're patenting. So I think I've done some that are very basic mechanical devices, little widgets that go in supermarket freezers, for instance. And I've also worked with some very complicated technology that's come out of research-intensive institutions. And obviously, those two inventions, whilst they both may be patentable, one will take me a lot more time to understand and write an application for, and therefore it's going to cost more money. Typically, I would give a range if you're filing a UK application, patent application, of somewhere between £4,000 and £6,000 ex-VAT, and I'd say most applications fall within that range, but it is very dependent on the technology. And if you wish to file at other offices, such as the European Patent Office, then the official fees are somewhat higher, and that will also influence cost.
Yeah. Likewise, with trademarks, we tend to operate on a fixed fee for filing the application, but costs can range quite significantly from country to country. So the UAE, for example, is very expensive, whereas the UK in comparison is quite inexpensive. So as I mentioned, when you're developing your strategy, it's probably worthwhile thinking about getting the UK one in there first, and then considering where you're going to file over the next few months.
Harry, you mentioned, or was it Sam? You mentioned the European Patent Agency, which is a complete separate entity from the EU. Would it make sense economically to go there straight and get a patent for across the European countries, or is it just the cost times X number of countries you would find?
So it depends on the particular strategy, particularly if you're a business and you know exactly where you're going to file and you know exactly what other prior art is out there, then you might file first at the European Patent Office. If you're a company that perhaps isn't sure what the prior art may be, the official fees at the UK office are a lot lower. So often, if, for example, we have a startup and they're not sure what's come before, we would say file first in the UK office because you're only going to have to pay the UK official fees first. And if some prior art is found that's very relevant, then you're not going to have lost as much money. Whereas if you've paid all of the official fees that are required for the EPO, that might be more expensive, and so might present more of a risk. So it depends on the information you have and the strategy that you then want to employ.
And it's not so many questions, so I'm hogging now the opportunity here. Is there any protection in the delay from when you file the patent or, for that sake, a trademark in a country, and there's a period till you get it approved, and really you would like also to have this done in another country, another jurisdiction? Is there any kind of protection in that period while you do that, or could somebody in the meantime who got the news of it rush off and register somewhere else?
So for the trademarks, as long as you file the foreign applications within that 6-month period, and those foreign ones go through to registration, you would effectively leapfrog something filed in that country, say 3 months after your first filing. So this is something obviously you have to be very careful of when you're searching, because someone may have filed in one of the countries you're not searching 4 months ago, and then file in your territory, and effectively backdate their right there to before your application. So as long as you get in within that 6-month window, you would leapfrog them. You don't have to file within the 6-month period. You could file 7 months after the first filing date, but then that new application would take that new filing date, and therefore you wouldn't leapfrog someone who'd filed 2 months prior, for instance. Sorry, it's a bit of a jumbled timeline there, but I guess file within the 6-month period where you consider the highest priority, and then take a view with a trademark attorney about where else you might file, maybe further down the line. If, for instance, like I said, you're only really interested in moving into a certain market in 5 years' time, it might not make sense to file in that country yet.
Very good. All right. I don't think there is many more questions. Though there was maybe the obvious one, Harry, you alluded slightly to it. Are there anything in the crystal ball on what's going to happen post December? Will the UK have a significant change of rules in terms of this, or can we expect it will be roughly the same process still?
I think it's going to be a similar process. Maybe in a few years' time, the laws will start to diverge, but for now, I think it's going to be business as usual. And yeah, carrying on as best we can.
Yeah, exactly. All right, everyone. I would like to wind this up now, because we're getting to the top of the hour, and let people move on. But I would like to thank you, everyone, hugely for being part of the webinar today, and in particular Sam and Harry and Mathys and Squire for letting us all in on the general around intellectual property, which is one of those things that you think we know a lot about, but when it comes to it, do we really? So I think it's good, if nothing else, to have it as a refresher for the ones of us who know a little bit about it, and also have the opportunity for the ones this is completely new to. After this webinar, you will be redirected to a feedback form. I'll really ask you all to take a moment to fill it in, because that is really only going to help us to make sure we do this even better next time. lastly but not least, if you have any questions follow on from this, there is an end slide here with some contact details to Harry, Sam, and I believe me as well. If not, you can find me on dkuk.org, and we'll be happy to help and facilitate those questions. Or indeed, if you have a specific project that you're working on, I'm sure both Sam and Harry would be happy to comment on it and give you some ideas to how to proceed, maybe even help further. Sam, Harry, do you have a final comment? You want to say anything?
No, just to say that thank you for everyone for joining, and like you mentioned, happy to answer any queries people might have by email or by phone.
Good.
Yep, thank you for joining.
All right. Thank you very much, everyone. Have a good day, and please do visit us again on our respective website, Mathys-Squire.com or DKUK.org for the next webinar, or indeed how we can help to assist in connecting you all. Thank you. Have a good day. Goodbye.